Hi. Okay, let's go ahead and get started. Thank you guys so much for joining us today. I know life is busy and there's always so much going on. So I think this is really great that you guys have taken the time out for this. We'll go about 30 minutes, and then we'll have some questions and answers. You'll see in the chat box, I dropped a link to a worksheet. If you don't mind filling that out, it always helps us just to better understand what is valuable information for us to provide and what you may have going on. So um, that would be really helpful if you could turn that in. But okay, welcome today to this conversation about estate planning. We are all parents here. This is really about how do we protect our kids and how do we protect our assets and what the heck is estate planning? I will always be the first to say that I think as legal educators, we have done a really poor job of teaching the general public what estate planning is. We colloquially hear about people saying, I need to get a will, but what does that mean and what are our options? So my practice, AB Law, is a practice that I founded about 2 years ago. And there we go. I was trying to move my screen over. So I am the founder of AB Law, and I'm a Texan. I have lived in Texas virtually most of my life, from Houston, done the circuit between Dallas and Austin, back to Houston now, but we practice throughout the state of Texas. I've been practicing for 17 years. I was a partner at a law firm for 15 years. And then about 2 years ago, I started my own law firm, and we are full service on the estate planning side and on the business side. And one of the main reasons I did that is because, kind of like I was just saying a second ago, I think that there's so much about the law that a lot of people don't understand. And it's because we haven't really provided the education to understand how the law can work for us and what the law has set up for us and how can we change that, and is it to our favor or not. So our law firm model is very education driven. We try to really focus on the intersection of law and education because I'm a strong believer in the more you know, the better choices you can make. And so that's really always my goal. Today, we're talking about estate planning. And for parents, there's two sides of the coin primarily for estate planning. There's the asset side. How are we going to get the money to our families? What's the best way to do that? The most strategic and savvy way to do that? Then there's the really important piece about the guardians for our children. Who are we leaving our kids to? I know for a lot of my young parents, that is one of the hardest pieces for people to reconcile. No one's ever going to be as great as you. And so how do we choose the right guardians? And so have no fear. I know that that's one of the main reasons people procrastinate on this. But we have a process and a system to kind of help you get to the right answer. No one will be as great as you, but you are always better equipped to make that choice than a judge could make for you and your family. So today we're going to talk about guardians. We're going to talk about protecting our kids, making the money work for us. Again, I'm a huge believer in the more you know, the more you can do, the more empowered you are. How do we make the law work for us? How do we make our money work for us? How do we take advantage of what is available to us? Some more specific things we're going to talk about is wills versus trusts. Again, we hear people talk about wills all the time. What is a will? What is a trust? What does that mean to us and our family? What are our legal rights? How do we protect our kids? And then, if we wanted to get a step deeper into all of that, if we want to be tax savvy and strategic, how do we minimize estate taxes? How do we bypass capital gains taxes? How do we build in asset protection if we want to protect the money that we're leaving to our children? Do we want to think about wealth generation? Again, that's all a little bit further. It's stuff that we're all equipped to do, and we'll talk about some of that today. But what we're going to spend most of today talking about is just the foundational building blocks of how do we protect our assets? How do we protect our kids? How do we make sure all of those things are accounted for after we leave? I know estate planning can be terrifying to think about. I will often say, because we haven't done a very good job educating the community about it, I think it's very poorly understood, misunderstood, not understood at all. And so because of that, it can be very intimidating and overwhelming. So today we're really going to break it down into its basic building blocks. Something I just like to remind folks is estate planning it's really about setting things up for our family. It's about making their lives easier after we pass. It's not about the actual event of death. It's about how do we pass the baton on and make things as simple and hassle-free as we can for our families. I know we've had a few people join, by the way, since we started the call. If you guys would just look at the chat, there is a worksheet that I dropped a link in there to a worksheet. If you guys could just fill that out, it'll really help us just better understand the questions you have. And at the end, we will absolutely answer any questions that you guys have. I'm happy to answer anything that's on y'all's minds. Okay, so back to estate planning. Good estate planning tackles 4 big areas. It tackles your assets, right? That's the equity that you have, your bank accounts, your 401ks, your home, just everything you own. There's your family, there's your kids. Who are your kids going to? How do we make sure they're taken care of? A piece of estate planning has to actually do with you and your comfort, right? So if you were incapacitated or if you were in a coma, how do we make sure the right people are speaking at your bedside? How do we make sure the right people can reach into your bank account and make sure that the lights stay on and the bills are paid? How do we make sure that your wishes are conveyed about whether or not you want life support, whether or not you want to be on a ventilator? That's all a piece of estate planning. And then if you happen to be a business owner, an important part is your business, right? How do we make sure that your business passes on to the people that you want it to pass on to, or that your family is actually able to extract the majority of the assets and the wealth there because you want that money to go to your family? How do we make sure it's not a fire sale or a distress sale? So that, again, that succession planning, that continuity of planning is all a part of estate planning. Okay, so let's talk about, most people will say, oh, they'll call me and they'll say, Arati, we don't have anything, right? We don't have a plan. We need you to help us with documents. And I always understand that this is something people put on the back burner. So there's no shame. You should feel no shame about that. But the truth is that you do have a plan, and that plan is the plan that the state of Texas has for you. And we're going to talk about that today, because for most people will say, now that I know what Texas's plan is for me, that's not the plan that I actually want. I want to create my own plan because Texas's plan is suboptimal or doesn't meet the needs that I want in place for my family and me. Okay, so what is Texas's plan? If you may or may not have a will, okay? If you have a will or if you don't have a will, either way, if you have a will or don't have a will, the process that Texas has in place for you is something called a court probate process. So even if you do have a will, you have to go through something called the court probate process. It is the only way that your will can be interpreted and administered and your assets can be distributed according to the wishes that you put in your will. Okay, so let's talk about what a probate process is, because this is where I realize there's, a lot of people say, oh, I need a will, but they don't realize what that means. Okay, so a probate process is designed for 2 primary reasons. The first reason is to notify creditors, right? There are a lot of Americans that have creditors, and it's a blanket process, one size fits all. And so by the very nature of that, because it's designed to notify creditors that this person has passed away, it is a very public process. It's public to the point where we have to publish it in the newspapers and notify people, hey, these people have passed away. Here's your chance. If you think you have a bite at this apple or a stake in this estate, show up at this hearing, file your claim here, and we will determine if there's dollars here that are owed to you. Okay. So because it is so public, that means a couple of things. It means we can't file anything under seal, okay? So that means it is essentially an airing of your financial laundry. Every dollar you own in the amount of where it's located, every dollar you own, where it's located, the amount that you're giving to each child or each beneficiary, when they're receiving it, how they're receiving it, all of that is public knowledge, okay? And because it is designed for creditors, your assets are frozen at the court level until the judge says, okay, we can now make the distributions. And then very publicly, we make those distributions. A lot of people don't love this process for a variety of reasons. One, it's public, right? There's no privacy here. Everyone sees your dollars and when your kids are getting those dollars. Assets get frozen. It can also be a very expensive and unpredictable process because you have to hire a lawyer to walk you through this process, and there is a judge and a court involved. So beyond it just getting expensive and unpredictable, it can also get really stretched out. It can get really drawn out and get really expensive. You kind of lose control in this process. So to just kind of summarize this, having a will, and even if you didn't have a will, having a will or not having a will means you go through probate, okay? like I said, private matters become public information. They are easy to contest. When we have a hearing of that nature, if there is ever someone who's going to raise some conflict or contest something, this is where they're going to do it. They're going to do it in a court setting. Attorney's fees and court costs can add up. Distributions aren't made until a judge orders it. If you happen to own assets in another state, if you happen to have a home in California or Florida or a vacation home in Colorado, that means 2 probate processes. Okay, so that means 2 courts are going through this asset distribution process. So that's more time, but also more dollars. And it's, again, it's drawn out. We know that it takes multiple months to complete. This is, again, not a very cost-effective process, okay? How do kids inherit under this process? Kids actually cannot inherit money until they turn 18. So that's the age when kids can start inheriting money. Your assets go through probate, and then the judge will appoint a financial guardian to overlook the assets that will eventually be assumed by your children. Who does the judge choose as the kids' financial guardians? We don't know, right? A lot of these things, when we haven't done our own planning, the judge does our planning for us. And many times it's not who we would want, but we've lost some control of the process by not doing it ourselves. And like I just said, when do kids receive the inheritance outright with no protections or guidance? This means all of your assets in their bank account without any further instructions around it at the age of 18, right? So I think, most of us being parents on the call, that's a lot of money to have in your kid's bank account at the age of 18 and then be able to do whatever they want with that, right? So that's, okay, this is, again, what I kind of explained earlier as Texas's plan, right? So this is if we haven't done any additional planning, this is kind of what's laid out for us. The one thing I want to make super clear, and I should have probably said this in the beginning, is my goal is never to motivate by fear or by gloom and doom. That is never the goal, okay? My goal is to educate you on the systems that are currently in place so that you know what is currently in place, and then you can be in a position to make better choices for you and your family, because there's a solution for everything. We have tools for everything. But the name of the game when it comes to estate planning is to be proactive. To be proactive, take action, and make the choices before the court or judges can make them for you, and then we're in a position of having to react. Something else that's kind of important here. If our families don't know what we own, the automatic default is it goes to the Texas Department of Unclaimed Property. That is already $6 billion, primarily funded by people not knowing what their families owned. So one of the things we do for all of our clients is we create a very comprehensive asset inventory that we keep electronically, and we continue to update over the course of time, because that's important, right? If I hadn't done this kind of planning for my parents, they had 15 different annuities and CDs around town that I had no idea that they had, right? And so not knowing what our families have means that we potentially could lose those dollars to the state, to the Department of Unclaimed Property. And the goal here is let's keep those dollars for our families and in our pockets. Okay, so now I've kind of told you how the will process works, how the probate process works. Like I said just a few minutes ago, again, the goal is education here. The goal is not to fill you with fear that this is all hopeless and futile and that there's no way around this. The good news is that we have ways to protect our families, protect our assets, protect beneficiaries. If we want to completely avoid the court process, we can. If we prefer privacy and flexibility and just not wanting to involve the courts, there are solutions for that. One of the most utilized solutions that I will tell you over 90% of my clients use now because they know it's an option is something called a living trust. You may or may not have heard about this. I would say, a couple of years ago, probably a few decades ago, there used to be a real stigma tied to trusts, right? That they were only for the rich and the wealthy. That's actually not true. That's a myth. What is a living trust? A living trust is a will substitute. It means no probate. So now it really, a trust has become a lot more mainstream. Like I said, over 90% of my clients use them, especially people with kids, but really kind of all across the board, because if you value privacy, and assets not going through court, and assets not getting tied up in court. And if you just want to be able to control your costs and have that flexibility, the living trust is the vehicle to do that and to be able to avoid the court probate process. You saw earlier that snake squiggly line of what a probate process looks like. This is what a trust process looks like. A trust process is actually much more straightforward. It is private. It is something that you can actually control. What exactly is a trust? A trust is a legal vehicle that's been designed to avoid probate. That's the primary reason that trusts were created. So now what we do is we take all of the assets that we have and we put them into the trust. Okay, so we transfer assets into the trust. The trust during the course of our lifetimes is tied to our social security number. So there's no additional tax implications, no additional financial implications. Our tax returns look exactly the same as they do now, but the trust essentially holds all of our assets. And now when we pass away, we don't have to go through the courts to distribute our assets or administer our assets or retitle our assets because we've already done that. So very privately, very seamlessly, and immediately, assets can be distributed as we wish, and nothing has to go through the courts. How does this work? Just like I was saying a second ago, we put all of our assets into a trust. Now, you know, folks will sometimes ask me, what's the downside of a trust? The one thing I will tell people is the trust requires a little bit more work now because we have to put our assets into the trust now, but we try to make that really easy for our clients, and we can actually do it for our clients if they wish. But I also tell people there's nothing that we're doing now that your family wouldn't have to do later. We either transfer assets and retitle them now into the trust, or otherwise your family has to do it in probate with a lawyer through the court process of retitling assets out of parental names into children names, right? Assuming that's how the beneficiary designation is going. So there's nothing that we're doing now that wouldn't have to be done later. So, okay, the way that it works is we put assets into a trust. Our trust agreement dominates. Our trust agreement tells us who's getting what and how we want things split up. And then assets are immediately distributed. No one ever sees the trust agreement. It's private. The courts are not involved. So it's just very straightforward and very clean. Again, these are called they're called revocable living trusts, RLTs. What does that mean? That means that nothing we do right now is permanent. We can interact with our assets exactly the same way. We can buy real estate, refinance real estate, sell real estate, open bank accounts. We use our assets, open bank accounts, use our bank accounts exactly the same way. It's just that now we have put everything into the trust, but we own the trust at 100%. Okay, so that's how that works. We put assets into the trust, but we own it 100%. So we've really just created an additional legal vehicle there, a layer to be able to avoid the court system. Okay, so again, this allows us privacy because we don't have to go through the courts. It allows us flexibility. It allows us to bypass the court's involvement. There's a lot of cost and time savings here. Trusts are actually the cheaper option because it's kind of a one and done. You do it one time, you set it up right, and you don't have to hire a lawyer again to go through the court probate process. And then if you choose to, there's additional cool things that we can do. Like we can build in some asset protection. We can do additional estate tax and capital gains tax minimizations. So there's just different things we have here that can work. You know, there's, for example, you know, a lot of us may have young children right now, right? We don't know what their future is going to look like. So we don't know if our children are going to get married and then get divorced. And if they get divorced, more likely than not, we don't want the future ex-spouse of our child to walk away with those assets, right? So there's ways that we can design for our inheritance to stay with our children and not be lost in things such as a divorce or a lawsuit or a car accident or creditors and anything of that sort. So there's just, again, a lot of things we can do to customize these and have them work for us. This is kind of where we go back to the more we know about the law, the more we can have the law work for us, the more we can have the laws benefit us and our families, right? And again, you know, as I always say, estate planning is really about being proactive and intentional and designing things so that they favor us and our families. Okay, so that kind of wraps up, at least for right now, that wraps up the asset side of things. At the beginning of the call, I said, you know, for parents, usually there's two big sides to the coin. when it comes to estate planning. There is the asset side that we just talked about, and how those assets get distributed to our children and what process and vehicle we want to use. Then there's this guardian side, right? There's this, we have minor children, who is going to be the guardian of our children. Again, this is one of the main reasons that parents come to me with young children, but it's also one of the main reasons people procrastinate, because they can never figure out who they want, or often they cannot figure out who they want to be the guardians of their children. And I understand that. I get that. No one will ever be as great as you as a parent to your children, right? This is a hard thing to do. And it's hard to decide, each home is maybe not perfect. There may be one thing in each home that may not really fit right. So we have actually designed a process at our firm where if there's a couple who's struggling with who's the best guardian fit for my child, we've designed a process where we can help go through the steps to identify which things we should give more weight to and which things we should give less weight to kind of help you figure out, okay, what makes the most sense. And, I also understand that, for example, a lot of people will say, oh, well, I want my parents to become the guardian of my children. But for example, my parents are in their 70s. So they're a fantastic choice right now, but in 5 years, they may not be a fantastic choice, right? And so those are all things we can talk about. And because we actually do complimentary 3-year reviews and check-ins every 3 years to make sure our plans are working the way that we intend them to be working, we can think about this in smaller, digestible chunks, right? Who's going to be the best guardian maybe for the next 3 years, but then that answer might change at the 6-year or the 9-year mark. When it comes to guardians, like I said, we have a process to be able to help folks understand or better wrap their heads around who the best guardian choice might be. But things to kind of think about. Often, it actually has less to do with money and more to do with who is more value aligned with you. What is the kind of value environment that you want your child to be raised in? They have similar ideologies to you. The one thing about money is that your assets will pass with your child, right? So sometimes folks will say, well, I have a family member in California or New York, or that I would really love my kids to go to, but they live in a shoebox, right? Or they just don't have the space for my kids. Those are all things we can work around. And those are conversations that we will have. But really, the most important thing is to really try to focus in on what will be the best home environment for your child. And again, these are conversations that we will have. And the next slide, this is, again, like I said, I never want to motivate by fear, but it's important for you to understand how the process works. So I think this is really important to realize and to kind of wrap our heads around. If we don't appoint guardians for our children, foster care is the default. Okay, so I'm going to say that one more time. If we don't appoint guardians for our children, foster care is the default. That seems stark. That's heavy. I know that hits a lot of people, kind of like knocks the wind out of them a bit. That's just really hard to think about. But if you actually do for a second put yourself in the shoes of a first responder, right? If you and your spouse got in a car accident, or maybe you don't have a spouse, you're single, but you've gotten in a car accident and the parents are gone. A first responder is not going to make the decision of which home is a safe place for your child to go, because they don't know what the family dynamics are. They don't know what a safe place is for that child to go. So a much easier decision, the one that has less red tape around it, is to stick your children in foster care until the courts open up, until we can find a spot on the docket that a judge can hear testimony and listen to witnesses and spend a lot of time deliberating and then figuring out who the guardians for your children should be. Okay, so that decision then gets made in the hands of a judge, which again is not ideal, right? Because the judge doesn't necessarily know what your family dynamics are like, and that your child could end up in a place that you may not want them to be. So again, this is really kind of if there's a reason to do this, it's a reason to really name guardians, okay? At our office, we actually take this a step further. So, here we're talking about long-term guardians. We're talking about where is the long-term home for your child. We take this a step further, and we do not only long-term guardians, but we also do something called short-term guardians. So going back to the, if you get in a car accident, right, on the way home from date night, if the guardians you have named happen to live in New York or California or even further away, like even a longer car ride, right? Like a 4 or 5 hour car ride from you or a 3 hour car ride from you. The default is still going to be foster care until your long-term guardians can arrive. Because again, first responders are not going to take that risk of putting your child in a home that they are unfamiliar with. Okay. So this is, our office actually does something called short-term guardians and long-term guardians. For some people, if those people live in the same city, then they end up being the same people. But for other folks where the long-term guardians live further away, short-term guardians are people who live in our community. They are people who live within 30 minutes of us, who we appoint as short-term guardians for that interim period until a long-term guardian can arrive. I actually think that this is huge. I think that this is really, really important because obviously we're trying to make things as palatable as we can in a high trauma situation. We're actually one of the only firms in Houston. I only know of one other firm in Houston that does this, that has these emergency guardians, but it's important, right? It's important to legally have someone be able to take your kids on in the event of an emergency until other guardians can come in. So again, guardianship, really, really important if you have young children. And it's something that you absolutely should be thinking about doing, because there's the money piece that's super important, but like just their safety and making sure they end up in the right homes. This is our time to make those decisions for them, rather than having a judge make those decisions for us. Okay. Having said all of that, so now we've talked about, just taking stock of what we've talked about. We talked about the assets. We've talked about wills versus trusts and the probate process, public sharing versus privacy. We've talked about guardians, long-term guardians, short-term guardians. Those are the big two heavy pieces of estate planning. But, when I earlier said that most of estate planning is about our families and making sure that things are as easy as they can be for our families after we're gone, that is still true. But I'd say there's a piece still about like a 10% piece that's about you, right? It's about you. What if we end up in a situation where we're incapacitated, right? So there are documents that should be prepared and things that should be considered because of you potentially being in a position where you can't speak for yourself. So the three main documents here are a financial power of attorney, a healthcare power of attorney, and then a health directive or a living will. A financial power of attorney is if you were incapacitated, if you're in a coma, who can reach into your bank accounts to pay your bills, keep your mortgage paid, maintain the status quo until you can return back to health. Or otherwise, we make some other decisions, but it's during a period of incapacity. Healthcare power of attorney, who can speak to your doctors and at your bedside when you cannot, right? You want to make sure that those are the right people. Who do you want making healthcare decisions on your behalf? And then a healthcare directive, that's to our family and our physicians. A lot of people have very strong opinions about life support. I think after COVID, a lot of us have really witnessed what life support can look like. For example, we saw a lot of people get on ventilators and get off ventilators, and those are conversations we would have, and really important conversations to have about where do you kind of fall in that space, right? That's an important dialogue to have. Is it that you absolutely don't want it, or do you want it until it nurses you back to a certain point? And so we have different like metrics and standards and benchmarks that we can just kind of talk through, but it's just important that your wishes are represented. So even your healthcare power of attorney or your family, for example, knows what's important to you and what you would want. The goal here is really just to stay in control with effective incapacity planning with those documents. And having our documents work when we want them to work, having our powers of attorneys work when we want them to work. I think a lot of us may be old enough to remember the Terry Schiavo case, right? That is when a family didn't necessarily know what maybe their daughter may or may not have wanted, right? And this really captured the national attention for a very, very long time. If we don't do our living wills correctly, if we don't document things, then it's hard for our wishes to be heard and recognized. Okay, so a couple of wrap-up points that kind of our big takeaways from today is, and then we'll open up for questions. Our children are our most important assets, right? There's tangibles and intangibles. Obviously, our family and our children are the most important. Who is going to take care of our kids if we don't make it home? Guardianship is equally about what happens in an emergency as it is about who raises your kids long term. Like I said, something really unique to our firm is those short-term guardians. A family member is not going to be able to necessarily step in unless a judge appoints them. This is kind of where you keep the control, you hold the control, you make those decisions instead of a judge making them later. Lesson number 2, wills do not avoid probate, and probates can be a long and public and costly process. So this is where we talked about wills versus trusts. Living trusts bypass the court process. They allow for privacy, immediate access to funds, and control. No one has to see who's getting what. Courts are never involved. Dollars go down to our families immediately. And it really just, it streamlines things, right? So trusts are not about how much money you have in the bank and much more about how you want to structure things and how you want your affairs handled after you're gone. Lesson number 3, a review of all your assets should be a part of your estate planning conversation. We didn't talk about this as much. We kind of touched on some of this stuff. We want to make sure that all your assets are accounted for. So first of all, we're not losing assets to the Department of Unclaimed Property, right? That's really, really important because we want to make sure that your family gets to keep your assets, not the state. But we want to make sure all of our assets are accounted for. We want to make sure that plan kind of grows with us, right? I think a lot of what we've seen, one of the largest pitfalls we've seen, and what we often are picking up from other estate plans or for clients who've had work done before and then come to us, is many times they'll get documents. They'll get a stack of documents. It's like a one-time transaction. It gets stuck on a dusty shelf and things get stale or outdated, or they don't work when they need to. Big life changes happen, asset profiles change, and the plan no longer works. So how do we make sure that we are growing with your assets, growing with your life changes? How is your plan evolving as you need to? At least at our firm, we do complimentary check-ins every 3 years because the goal is we know that things are going to change and we want to be able to grow with that. And then, if you want the option to minimize taxes and build an asset protection, make sure that you're able to do that. Those are important considerations because every family is different, but it's good, again, to know what your options are and what's on the table as an option for you. The big takeaway is estate planning requires intentional action. Planning keeps us in control, keeps us informed. It's a huge cost savings. If you plan now, you are guaranteed to save yourself hundreds and thousands of dollars in the long run because you, again, can get ahead of it, you can be savvy, and you can plan strategically. The state of Texas's plan is not ideal for most families. Probate is usually not what most families want to go through. If you've ever talked to anyone who's gone through probate, they'll tell you that it was a painful, exhausting process and that they wish they didn't have to. So, again, the big takeaway is you should be thinking about these things and you should be thinking about planning. Okay, just as far as who we are, I get this question a lot about how we kind of do things differently than other practice. We actually do a lot of things differently than other practices. We're very education focused. So we spend a lot of time educating clients on options. The way that we do things at our firm is we have our clients fill out a worksheet before we ever start the process. We spend about 2 hours reviewing that worksheet. That worksheet is information on their asset profile and their family profile so that we can come up with the right size solution for our clients. I always tell our clients that I'm not going to ever offer anything that's not the right size solution or not custom designed for them. I'm not going to offer anything that doesn't save them hundreds or thousands of dollars. It has to make good economical sense. And we're also not a one and done and out of there. We always hold documents electronically. We stay engaged. And if something happens, we're right there to help families pick up where we left off and actually execute the plan and put it in action. So those are promises and hallmarks of our firm. As far as other things that we do, we stay engaged for the long term, but we're also flat fee. We do comprehensive asset inventories because that's really important. And we just kind of stay engaged. We don't charge for any of our sessions because I think there's so much more value in just the conversation and the dialogue. And because I know most of our clients are very, very busy people, we send notaries to them and all of this can be done from your home. So you never have to leave your house to get really comprehensive, thorough estate planning done. We can send everything to you and make your lives really, really easy that way. Okay, so, if something I said today resonated with you, and if you have questions and you have thoughts about what does this mean for my family, or what should I do next, or you made me think about something, or you triggered a thought, I would encourage you to reach out. Like I said, we don't charge for any of our phone calls. The first thing I would do is have you reach out and set a 15-minute phone call, and we can kind of talk through things. At our firm, like I said, everything we do is flat fee. We have wills packages that start in the 2000s, trust packages that start in the 4000s. Again, that means that the trust package is more expensive than the wills package. But like I said before, the wills package is guaranteed to always be the more expensive one, because you're going to have to hire a lawyer later, and you're going to have to go through the court probate process later. The trust package usually will just kind of stop at that one-time investment. Everything we do is flat fee and agreed to in advance, no surprises. And again, we're just very comprehensive in our approach. Like I said, our trust plans start in the 4000s, and that will keep you out of court. But if you decide you want to do special advanced tax planning or advanced asset protection, it can go up to the 8000s. That is 100% up to you. You can choose to do that, or you absolutely do not have to do that. The choice is up to you. The more you do with the advanced planning, that can often save our clients millions, but even the basic trusts save our clients many thousands. So you get to kind of pick your own adventure on this and figure out where you want to land and what plan makes the most sense for your family. I never force anyone into anything. I'm just really here to kind of educate and explain and let you know what your options are. And then you figure out what makes sense for you guys. But overall, the planning keeps you in control, keeps you informed, and it ends up being a huge cost savings. And with all of our plans for families with young children, we do all the guardianship work at. So that's the long-term guardians, the short-term guardians, wallet cards for first responders, and we even do powers of attorney for minor children. So we include that in all of our plans. And just as a special bonus for you being here today and for listening to this presentation, because I know that the biggest risk to families is procrastination, I am offering a complimentary virtual one-on-one meeting to anyone who wants to have any of their questions answered, wants to talk further about things. And on top of that, if you decide you actually do want to plan, we'll offer a $300 discount if you want to actually book a design session. So the next steps from here, if you were interested in planning, is that you would book a 15-minute session with our firm. And then we would have a conversation. And if you said, okay, it's time, we want to, actually kind of book a session, book a 2-hour session. Those 2-hour sessions that we have, again, are complimentary. And for that 2-hour session, I would send you a worksheet. You would fill out the worksheet. We have a complimentary 2-hour session. And then you decide, do I want to design or do I not want to design? What's the next best step for me? So, okay. I think we've made it through most of our information today. But I'm happy to answer any questions that you guys have. You can see this Calendly right here, or you can use this QR code. That can take you right to our Calendly. That can take you to our website and to our booking page. If you either wanted to book a 15-minute session to talk more, or if you think you've heard everything you needed to hear, and if your thought is, hey, let's just jump right into the planning because that's really what we want to do, you can book, like I said, a free 2-hour session where half of that is education-based. We're dialoguing, we're talking about you. It's very specific to you, very specific to your family. And we figure out what the right plan is for you guys. And I kind of guide you along based on the information that you've given me and the goals and objectives that you have for you